Shariah Standard Number 11, Istisna'a and Parallel Istisna'a, in the name of Allah, the All-Merciful, the Most Merciful. All praise be to Allah, the Lord of all the worlds, and blessings and peace be upon our Master, Muhammad, and his household and all his companions. Preface. The objective of this standard is to explain the Sharia rulings and limitations applicable to Istisna'a and Parallel Istisna'a transactions in respect to concluding an Istisna'a contract, the subject matter of Istisna'a and changes to the contract. The standard also explains issues relating to the execution of the contract and the supervision of its execution. Statement of the standard. 1. Scope of the standard. The standard covers Istisna'a and Parallel Istisna'a transactions whether the institution is acting as an ultimate purchaser, or is acting as a manufacturer, or as a builder for construction. 2. Istisna'a contract. 2.1. Conclusion of an Istisna'a contract at the time of contracting or after the bilateral promise. 2.1.1. It is permissible that the institution and a customer conclude an Istisna'a contract before the institution assumes title to the subject matter to be sold to the customer or to the materials from which the subject matter will be produced, manufactured, or constructed. 2.1.2. It is permissible for the institution to benefit from any price offers or quotations that the customer has obtained from other dealers or suppliers to assist it in the evaluation of expenses and the computation of prospective profit. 2.1.3. It is not permissible that the institution's role in the Istisna'a be that of a financial intermediary between a buyer and a third party, especially if the buyer has become unable to meet his obligations toward such a third party, and this prohibition applies whether such a role would take place before or after the commencement of the work. See item 4.2.2. 1. The Arabic term istisna applies to both manufacturing and construction, and there is no convenient term in English that covers both manufacturers and builders. Therefore, the term manufacturer will be used in this standard to designate a party acting as manufacturer or contractor in an Istisna'a contract, and the term subject matter will be used to designate the goods or buildings that are the subject matter of the contract. 2.2. Form and conditions of an Istisna'a contract. 2.2.1. A contract of Istisna'a is binding on the contracting parties provided that certain conditions are fulfilled, which include specification of the type, kind, quality, and quantity of the subject matter to be produced. Moreover, the price of the subject matter must be known and, if necessary, the delivery date must be determined. If the subject matter does not conform to the specification agreed upon, the customer has the option to accept or to refuse the subject matter. 2.2.2. Since a contract of Istisna'a is binding, the parties to the contract are inevitably bound by all obligations and consequences flowing from their agreement. In other words, the contracting parties need not to renew an exchange of offer and acceptance after the subject matter is completed. This is different from the promise in a contract of murabaha, which requires the signature of a sale contract through a new offer and acceptance by the parties when possession of the items to be sold is taken by the institution. 2.2.3. It is not permitted for the manufacturer to stipulate in the contract of Istisna'a that he is not liable for defects. 2.2.4. It is not permissible to conclude Istisna'a contracts or processes of Istisna'a in a manner that makes it a legal device for a mere interest-based financing. Examples are a transaction in which the institution buys items from the contractor on a cash payment basis and sells them back to the manufacturer on a deferred payment basis at a higher price, or where the party ordering the subject matter to be produced is the manufacturer himself, or where 1/3 or more of the facility in which the subject matter will be produced belongs to the customer. All the circumstances mentioned above would make the deal an interest-based financing deal in which the subject matter never genuinely changes hands, even if the deal is won through competitive bidding. This rule is intended to avoid sale and buy-back transactions. Bay'al-ina. 3. Subject matter of and guarantees in Istisna'a. 3.1. The rulings concerning al-masnu. 3.1.1. An Istisna'a contract is permissible only for raw materials that can be transformed from their natural state by a manufacturing or construction process involving labor. Therefore, Istisna'a is valid only insofar as the supplier has agreed to provide a subject matter that is manufactured or constructed. 3.1.2. It is permissible that a contract of Istisna'a be concluded for the production of a subject matter having unique descriptions according to the requirement of the ultimate purchaser, even if such a subject matter has no substitutes in the market, provided the subject matter is subject to specification. Similarly, it is permissible that the subject matter of a contract of Istisna'a be items that have perfect substitutes in the market and can be substituted for one another in fulfilling an obligation, because they share common characteristics by virtue of the process of manufacture or construction. This rule applies whether the items to be produced are intended for consumption or for use with their substance kept intact. 3.1.3. It is not permissible that the subject matter of an Istisna'a contract be an existing and identified capital asset. For example, it is invalid for the institution to conclude a contract to sell a particular designated car or factory on the basis of Istisna'a. This is because Istisna'a is a sale contract applicable to items that are identified by specification, not by designation. Unless the items are completely or partially delivered, the ultimate purchaser has no prior right, in the event that the supplier is declared bankrupt or insolvent, over a third party to the items that are the subject matter of the contract while they are still in the process of being produced and have not yet been delivered to him. In addition, the ultimate purchaser cannot be regarded as the owner of the materials in the possession of the manufacturer for the purpose of producing the subject matter of the contract, unless the manufacturer has previously undertaken, as a guarantee for the completion of the work, that such materials will only be used for the order of the ultimate purchaser. 3.1.4. The contract of Istisna'a may be concluded with a condition that the production shall be carried out by the institution using its own resources, in which case it has to abide by this condition, and has no right to assign the process of production to another entity. 3.1.5. It is permissible for the manufacturer to fulfill his obligation in an Istisna'a contract by using items produced by his own resources or items produced by other parties that existed before the contract was concluded. The latter option is, however, only valid if the ultimate purchaser did not stipulate that the manufacturer should use his own resources. However, this rule should not be used as a device for deferment of consideration, the price and the commodity, of a sale of a subject matter that is to be delivered in the future based on its specification as given by the seller, but which are not intended to be produced. 3.1.6. The manufacturer is under an obligation to produce the subject matter according to specification, and within the period agreed upon, or within such reasonable time as the nature of the work may permit, in accordance with accepted practice that is recognized by experts. 3.1.7. The parties may agree on a period during which the manufacturer will be liable for any defects or the maintenance of the subject matter. They may also leave the determination of liability relating to defects and maintenance to customary practice. 3.1.8. It is permissible to draw up an Istisna'a contract for real estate developments on designated land owned either by the ultimate purchaser or the contractor, or on land in which either of them owns the usufruct. This is permissible because the contract involves the construction of specified buildings that will be built and sold according to specification, and the contract of Istisna'a in this case does not concern a particular identified place, i.e. the land. 3.2. Price and guarantees of Istisna'a contract. 3.2.1. It is a requirement that the price for an Istisna'a contract be known at the conclusion of the contract, in which case it can be in the form of cash or tangible goods or the usufruct of an asset for a particular duration, whether such usufruct is related to an asset other than the subject matter or to the subject matter itself. The use of usufruct of the subject matter itself as consideration for an Istisna'a contract is relevant to situations when a government offers a preferential contract giving usufruct to the builder or manufacturer for a particular duration, commonly known as Build Operate Transfer, BOT. 3.2.2. The price of an Istisna'a contract may be deferred or paid in installments within a certain period of time, or if delivery of the subject matter is to be made in stages, a portion of the price may be paid immediately while the balance is paid by installments according to the stages of delivery. It is also permissible to connect payment with the stage of completion of the work, such that a payment is made at the end of each stage, provided the stages of this type of work are by custom subject to specification, and their identification will not lead to dispute. 3.2.3. If the process of manufacture or construction is divided into phases, or payment is designed according to the stage of completion of the work, then the manufacturer or contractor is entitled to request that the ultimate buyer make payment accordingly for each stage that has been carried out according to specification. 3.2.4. It is permissible that the price of Istisna'a transactions vary in accordance with variations in delivery date. There is also no objection to a number of offers being subject to negotiation, provided that eventually only one offer will be chosen for concluding the Istisna'a contract. This is to avoid uncertainty and lack of knowledge that may lead to dispute. 3.2.5. A contract of Istisna'a cannot be drawn up on the basis of a murabaha sale, for example, by determining the price of Istisna'a on a cost-plus basis. 3.2.6. If the actual costs incurred by the institution to bring the subject matter to completion are substantially less than the estimated costs, or the institution secures a discount from the party with whom it contracted on a parallel Istisna'a basis to acquire the subject matter in order to fulfill its contractual obligation, the institution is not obliged to give a discount to the ultimate purchaser, and the latter is not entitled to the amount or part thereof the institution has gained over the estimated costs. The same rule applies conversely when the actual costs of production are substantially greater than the estimated costs. 3.3. Guarantees. 3.3.1. It is permissible for the institution, acting either in the capacity of the manufacturer or of the ultimate purchaser, to give or demand accordingly arboun as a guarantee, which will either be part of the price, if the contract is fulfilled, or forfeited, if the contract is rescinded. However, it is preferable that the amount forfeited be limited to an amount equivalent to the actual damage suffered. 3.3.2. In an Istisna'a contract, it is permissible for the institution, whether acting in the capacity of manufacturer or in the capacity of the ultimate purchaser, to demand guarantees that it considers sufficient to secure fulfillment of its rights against an ultimate purchaser or a manufacturer. It is also permissible for the institution, when acting in the capacity of an ultimate purchaser, to give guarantees requested by the manufacturer, which can be in a form of a mortgage, personal guarantee, assignment of rights, a current account, or an investment account, or consent to blocking withdrawal from an account. 4. Changes to Istisna'a contract. 4.1. Amendments, changes, and introduction of new conditions. 4.1.1. It is permissible, after the conclusion of an Istisna'a contract, for the manufacturer and the ultimate purchaser to agree on amending the manufacturing or construction specifications previously agreed upon or introducing additional specification requirements on condition that the price is adjusted accordingly and a reasonable period for the execution of the new requirements is granted. It is also permissible to state in the contract that the consideration for amendments or introduction of additional requirements shall be determined and added to the original price as per the expert opinion, custom, or an identified price index which preclude any uncertainty that may potentially lead to dispute. 4.1.2. The ultimate purchaser cannot oblige the manufacturer to introduce modifications and changes to the subject matter of an Istisna'a contract without the consent of the manufacturer. 4.1.3. It is not permissible for amendments and changes to the contract to be agreed on the basis that an additional sum will be paid in consideration for an extension of the period of payment. However, a rebate for prepayment is permissible provided it is not stipulated at the conclusion of the contract. 4.2. Intervening contingencies, force majeure. 4.2.1. It is permissible, by way of agreement of the contracting parties or arbitration or judicial procedure, to amend the contract price of an Istisna'a contract upwards or downwards, as a result of intervening contingencies, force majeure. This rule must be read together with item 4.1.3. Above, 4.2.2. It is permissible for the institution to replace a contractor and enter into an Istisna'a contract with a customer to complete a project which had been started by the previous contractor of such a customer. In this case, an assessment of the project should be undertaken on the basis of the existing status of the project. The cost of this assessment is chargeable to the account of the customer, in which case all outstanding debts, if any, that arise from the incomplete Istisna'a contract shall be the personal responsibility of the customer. The parties may after this conclude a new Istisna'a contract for the remaining work. The institution is not bound to deal with the previous contractor. Rather, the institution has the right to stipulate that the work needed to complete the project will be carried out by any means it deems fit. 4.2.3. In the case of constructing buildings or public utilities on land owned by the ultimate purchaser, it is permissible to stipulate that the ultimate purchaser has the right to perform the contract of Istisna'a at the expense of the manufacturer if the latter fails to perform the contract or to complete the work within a particular period of time, and that this performance will be effected from the date the manufacturer halted the work. 4.2.4. If the contractor is unable to continue to discharge his obligation, the ultimate purchaser, the owner of the land, is not entitled to acquire ownership of the incomplete building structures or utilities that are already in place without giving consideration to the contractor. However, this rule depends on the cause of the failure to continue the work. If the failure to perform is due to the misconduct of the contractor, the ultimate purchaser is liable only for the value of the building structure, and the builder is liable to compensate the ultimate purchaser for any actual damage or loss he suffered. If the failure to perform is due to the misconduct of the ultimate purchaser, the contractor is entitled to the value of the work he has completed in compensation for any damage or loss. However, if the failure to perform has not been caused by either of them, the ultimate purchaser is liable only for the value of the building structure that is already in place, and neither of them has any responsibility to pay compensation for the loss or damage the other party had suffered. See item 4.2.3. 4.2.5. It is permissible that a contract of Istisna'a includes a clause to the effect that if any additional conditions are inserted into the contract at a later date as a result of directives of the relevant authorities, and these additional conditions lead to extra expenses that cannot, by virtue of the terms of the contract, be borne by the manufacturer because they were not in the original contract as signed or there is no law making such payment compulsory, the extra expenses will be borne by the ultimate purchaser. 5. Supervision of the execution of an Istisna'a contract. 5.1. It is permissible for the seller and purchaser to appoint technically experienced consulting firm to represent it in determining whether the subject matter conforms to the contractual specification, and to advise the institution as to whether payment for the subject matter, or delivery, or acceptance of it, under the terms of the contract, should take place, and they should adhere to its resolutions. 5.2. It is permissible for the institution, when acting as the manufacturer, to draw up an independent and separate contract of agency appointing the ultimate purchaser as an agent of the institution to supervise the manufacturing or construction process, so as to ensure that the items produced conform to contractual specification. 5.3. It is permissible for the manufacturer and the ultimate purchaser to agree on the party who will bear the additional costs of supervision of an Istisna'a contract. 6. Delivery and disposal of the subject matter. 6.1. The manufacturer is discharged from liability if the subject matter is delivered to either the ultimate purchaser, or to a person appointed by him, or if the ultimate purchaser is enabled to exercise full control over the subject matter. 6.1.1. If the condition of the subject matter does not conform to the contractual specifications at the date of delivery, the ultimate purchaser has the right to reject the subject matter or to accept it in its present condition, in which case the acceptance constitutes satisfactory performance of the contract. It is also permissible for the contracting parties to agree on acceptance of a subject matter that fails to conform to the specification even if such an arrangement involves a price discount. 6.1.2. If the seller offers to deliver a better quality, then the purchaser shall accept his conditions, provided that the seller shall not charge any additional amounts for the better quality, which may be considered one of the ways in which a contract is ethically fulfilled, unless the quality specified in the contract is particularly pursued by the purchaser. 6.2. It is permissible that delivery of the subject matter takes place before the due date, on condition that the subject matter meets the specifications agreed upon, in which case the ultimate purchaser is obliged to accept the subject matter. If the ultimate purchaser is unwilling to take delivery of the subject matter, the rule on this point depends on whether or not there is justification for this refusal. If there is a good reason for the rejection of the subject matter, the ultimate purchaser shall not be obliged to accept it. If there is not a good reason for rejecting it, then the ultimate purchaser will be obliged to accept the subject matter. 6.3. The delivery of the subject matter may take place through constructive possession, by enabling the ultimate purchaser to take control over the subject matter after the production process is completed. At this point, the liability of the manufacturer in respect of the subject matter comes to an end, and the liability of the ultimate purchaser begins. If after enabling the ultimate purchaser to take control over the subject matter any loss or damage subsequently occurs to the subject matter without any proof of negligence or misconduct on the part of the manufacturer, then the ultimate purchaser is liable. This is therefore the demarcation line between the liabilities of the two parties, the liability of the manufacturer and the liability of the ultimate purchaser. 6.4. If the ultimate purchaser refuses to accept the subject matter without a good reason after he is enabled to take possession, the subject matter will remain in the possession of the manufacturer on a trust basis, in which case the manufacturer will not be liable for loss or damage that occurs to it, unless such loss or damage is a result of negligence or misconduct on the part of the manufacturer. The ultimate purchaser bears the expenses for the safekeeping of the subject matter. 6.5. It is permissible to state in a contract of Istisna'a that the manufacturer will act as the agent of the ultimate purchaser to sell the subject matter if there is a delay on the part of the purchaser in taking delivery of the subject matter within a particular period of time. In this case, the manufacturer will sell the subject matter on behalf of the ultimate purchaser and, after deducting the agreed contract price, the balance, if any, will be returned to the purchaser. If the price obtained is less than the contract price, the manufacturer shall have a right of recourse to the ultimate purchaser for the recovery of the remaining balance. In addition, the ultimate purchaser will bear the expenses incurred in selling the subject matter. 6.6. It is permissible for the contract of Istisna'a to include a fair penalty clause stipulating an agreed amount of money for compensating the ultimate purchaser adequately if the manufacturer is late in delivering the subject matter. Such compensation is permissible only if the delay is not caused by intervening contingencies, force majeure. However, it is not permitted to stipulate a penalty clause against the ultimate purchaser for default on payment. See item 2.1.2 of the Shariah Standard number 3 on procrastinating debtor. 6.7. It is not permissible to sell the subject matter prior to taking either actual or constructive possession of it. See item 6.4. However, it is permissible to conclude an Istisna'a contract to sell an item on the basis of description or specification that is similar to an item to be acquired from a manufacturer, and this is called Istisna Muwazi, parallel Istisna'a, see item 7. 6.8. It is permissible for the institution acting in the capacity of ultimate purchaser to appoint, after taking possession of the subject matter, the manufacturer as an agent to sell the subject matter to latter's customers on behalf of the institution. This agency is permissible whether it is carried out free of charge or for consideration either in the form of a fixed fee or a particular percentage of the sale price, on condition that the contract of agency and the contract of istisna were not entered into in connection with each other. 7. Parallel Istisna'a. 7.1. It is permissible for the institution to buy items on the basis of a clear and unambiguous specification and to pay, with the aim of providing liquidity to the manufacturer, the price in cash when the contract is concluded. Subsequently, the institution may enter into a contract with another party in order to sell, in the capacity of manufacturer or supplier, items whose specification conforms to the wishes of that other party, on the basis of parallel istisna, and fulfill its contractual obligation accordingly. This is permissible on condition that the delivery date stipulated in the parallel sale contract must not precede that stipulated in the original purchase contract, and, moreover, the two contracts should remain separate from each other. See item 3.1.4, 7.2. It is permissible for the institution, acting in the capacity of the producer or supplier, to conclude an Istisna'a contract with the aim of selling such items to the customer on a deferred payment basis, and to enter into a parallel Istisna'a contract on an immediate payment basis with a manufacturer or builder to acquire such items as per the specifications in the first contract and sell them to the customer. This is permissible on condition that the two contracts should remain separate and, moreover, be subject to the matters set out in item 3.1.4, 7.3. As a result of concluding an Istisna'a contract in the capacity of a producer or supplier, the institution must assume liability for ownership risk and maintenance and insurance expenses prior to delivering the subject matter to the ultimate purchaser, the customer. Moreover, the institution is not permitted, in the parallel Istisna'a contract concluded with the manufacturer, to transfer to the latter the risk arising from its obligations towards the customer. 7.4. It is not permissible to make any contractual link between the obligations under two contracts, the contract of Istisna'a and the contract of parallel Istisna'a, when they are concluded. Therefore, it is also not permissible for a party to an ordinary Istisna'a contract, to withdraw his contractual obligations or delay delivering the subject matter of the contract because the obligation under parallel Istisna'a did not take place, or 2. To increase the price of the goods to be delivered because of an increase in the cost of goods in the parallel Istisna'a. However, there is no restriction on the right of the institution to stipulate conditions and requirements when concluding a parallel Istisna'a contract as a purchaser, including a penalty clause similar to, or different from, that which the customer has stipulated in the first Istisna'a contract in which the institution is the supplier.